Thank you. And we want to thank Todd and Amanda for inviting us to come and share our knowledge with you. Sorry, can you hear me now? Okay, commercial. We both are parents of special needs children, and we've been through the process both as mothers and as advocates. And we understand what it's like when you go in as a parent and you're sitting there facing 10, 15, 20 people who allegedly are there for your child and hopefully are there for your child, but also have their own agenda. So we did reach out, and we both took a course at University of San Diego separately. We completed the course, as did all the advocates at Pacific Coast Advocates. We went through a challenging internship for low-income children in San Diego, and we gained a lot of experience that way. That's how we have built up our knowledge, so we do kind of speak the talk that the school districts do when you're sitting there in the IEP meetings. And it can make a difference. It definitely can make a difference to have somebody with you who knows what the school district is trying to say, who knows what the school district is willing to offer, who knows what you can get the school district to offer even if they're not willing to offer it. And we want to share some of that with you today. So feel free to ask us questions. We will also leave time at the end for any questions or for any personal private questions. You can speak to us separately after. So again, my name is Tricia Palguta. This is Christy. Christy can...
Christy Scadden.
Okay.
And a lot of these things we also, we pick things that we wish we would have known when we were new to this. So hopefully we can pass some of that along to you.
Yeah, absolutely.
So the big picture, with this PowerPoint, we're going to start big, and then we're going to drill down into a lot of these areas so that you can get more information. So even if you're experienced and you have some knowledge of the process altogether, we'll get deeper into it as we go along. So these are just some terms, and in your packets, actually, we have several pages of terms that are even outside of what's in this PowerPoint.
Okay. And actually, before we get deep into it, just so we have an idea of the existing knowledge already, I know Todd already asked how many people have been to an IEP meeting, so we have an idea of that. Have any of you used an advocate before? You have? Okay. So you have an idea of what advocates do. And then can we get an idea of how many have children that are between 0 and 3 right now? Decent number.
And then how about primary, like up through 6th grade? Okay, and how about high school? Like, okay. Okay, great. Thank you.
Okay, and then again, right before we get into IEPs and the IDEA, the people who have children between 0 and 3, I assume right now you have individual family service plans? Okay. If you have any questions about those, we're happy to answer those also. This presentation really is focused on IEPs, but we do have knowledge about that also. So just to start off with, the IDEA is the federal law that implements the IEPs. It establishes, rather, the IEPs. And it gives a minimum basis of what states need to do for kids in special education. Each state then enacts their own laws, which can just have the minimum standards that the federal government has set, or they can maximize on it. And some states do in different areas. California has a couple places where they did, a couple places where they didn't. But each state is different. So as we're going through this presentation, realize that your state, the laws may vary, and you need to check them also. A lot of what we're saying is more of a national standard, but there are some California-specific things.
Yeah.
Sure. Sure. Okay, sorry.
So what's included in an IEP? These are just the components of an IEP, and we'll delve into this deeper. But you'll always see a statement of your child's present levels of performance. That'll include their strengths and interests. Your parent concerns, one of the most important pieces of the IEP. Your child's annual education goals, supports and services that the district is going to provide for you, for your child, accommodations and modifications for your child that will help level that playing field for them, having access, and then how the school will measure their goals and when, how often, and then transition planning for those that are 14 and 16 and up. That'll be part of it as well.
And I want to point out, I think Christy and I both agree, parent concerns are very important, and you need to bring them to the attention of the school. There's an area on the IEP for parent concerns. Put down everything that you are concerned with, that you want the school to address, and make sure that you do that. When the IDEA was passed, Congress made it very, very clear that parents needed to have input in the IEPs. It's part of the procedural safeguards, and by law, the schools do need to listen to you. They cannot do anything without your input. They can't even put your child in a placement without your input. And hopefully you'll never be going down the line of having to file for due process or hire an attorney. But in case you do, it's good to have down in the document and in the IEP meeting notes all of your concerns and the fact that it was brought to the school's attention. So some of the major terms that schools will use and everybody listens to, two of the biggest ones are FAPE and LRE. FAPE is the Free Appropriate Public Education, and that's what's guaranteed by the federal law, the IDEA. And what it means is that the schools have to provide an education at no cost to the parent. It has to be tailored to the individual needs of the child, and that's a key thing also. They have to look at each child. We'll get into this further. They have to assess them. They have to know what their strengths are, what their weaknesses are, and tailor the program for that individual child. And it has to be provided by the public school system in your district, and it has to provide some educational benefit to the child. That one's tricky. That one varies state to state. California does not have a lot of protections on that. It's a basic floor of opportunity. It doesn't have to be much benefit whatsoever. Other states have, it has to be a meaningful benefit. Right now, it's arguing in the federal courts. Different circuits, the highest appeal courts have said, oh, it has to be a meaningful benefit. Different ones, such as in California, have said, no, it doesn't. It just has to be some small benefit, just something that they can prove that there's a benefit. It's in front of the Supreme Court right now, and the Supreme Court is trying to decide whether or not they're going to take this issue on. They've asked the Attorney General to weigh in and say whether or not it's a case that they should take. I personally really hope that they take it, and I really hope they find that what Congress wanted was a meaningful benefit. But this is also very important when it comes to your child's IEP, because the schools don't want to give you as much as you want. It's kind of what Todd said earlier. So just so you have an idea of what the actual standard is, you're going to have to look in your own particular states to know whether you have better coverage than others, but if you're California, you don't.
That's going to bring us to that word appropriate again. So this is just delving more into that idea. You know, we want the luxury model for our kids, right? We want the best, we want the most. We want the best schools, the best teachers, the best opportunities. But really, public education is a baseline, right? It's about the car, it drives, it's the economy model, it gets the job done. So really looking at it, if you understand that perspective of how a district, how the law is interpreted with providing those basics for your child, really looking at identifying need for your child is really important. So really be thinking about that, and like Tricia said, that assessment piece is really how that you're gonna be determining that.
Yeah, absolutely. And again, just federal courts. One did compare a Chevy and a Cadillac and said, basically, the school wants to give a Chevy and the parents want a Cadillac, but all the school has to give is a Chevy. And then the general rule really is it doesn't need to be the best, and it doesn't have to maximize student potential. So even though you do want what's best for your child, the school district isn't always going to be willing to give that. So. And least restrictive environment, LRE. This is another big one. Both FAPE and LRE, you'll hear in IEP meetings, you can use them to your advantage. Least restrictive environment is that every child needs to be in an environment. The gold standard is general education with typical peers. And then it goes down and it gets more restrictive after that. It can be a resource room, it can be special day class, it can be residential or day treatment, residential treatment, et cetera. But what the law says is to the maximum extent appropriate, children with disabilities should be educated with children who are not disabled. And that means even if your child is in, say, a special day class, they need to have access wherever it's appropriate, because remember, it has to be an individual decision because the whole IEP is based on your child's needs. But they have to have access to their typical peers. And that can be done at lunch, at recess, in the library, through art, through other classes where even if they're not on the same level with grade standards, they're still interacting with their typical peers because both they and their typical peers can learn so much from each other. And that is, I'm sorry, go ahead.
Well, this is when you look at those strengths and interests part that's at the very beginning of an IEP. You know, if your child really loves, I don't know, science or the story time, then this would be a time for you know, the general education part. So really looking at those things as well helps to determine that. Also, least restrictive environment, even though there is kind of a common knowledge, a flow chart, you know, really of what is less and what is more in general, that also needs to be individualized. So for some, being more restrictive might be less restrictive for other students. So really thinking about this through your child's needs and not through the program or kind of how the district runs it is really important. So this section we're going to talk about how these pieces fit together and what you need to know with them specifically.
Yeah, essentially what we're going to go through right now is some of the sections that you're going to see in the IEP when you're faced with it. Parent concerns and input. As I stated earlier, it's one of the first things in the document, and I can't tell you how many of my clients, when I first come in, I look at their previous IEPs, there's nothing there. It's really very important. You are your child's advocate, and you absolutely need to let the school know everything that your child needs, and the parent concerns need to get in there, and you need to throw it back at the school and say, look, I'm concerned about this, what are you going to do to fix it? Or my child needs this, what are the steps that we're going to take, what supports, what services are you going to give us so that my child can go from A to B to C? And this is one of the first areas where you can do it. Yeah, I don't know.
This, you don't have to be an educator to be able to do this part. This is from your heart. This is your heart for what you want for your child. Don't leave anything out. Some of my clients bring a whole page, sometimes a page and a half. You can bring as much as you want. Type it out ahead of time. It is nice if it's bulleted and prioritized. It's easier for the team to go through, but I wouldn't leave anything out of it. This is your time to talk about what you're concerned about for your child. Sometimes it's even during that transition time or access to activities that maybe aren't necessarily academic. There might be other things around school. Maybe it's about what you want for your child when they get bigger. Just, you know, think about that as it's your heart. This is a really important part. I can't say enough about this. And the other section that I always encourage parents to come to the meeting with something prepared is that your child's interests and strengths. You know, the schools, this is their way of looking at your child and connecting to your child, really. So giving them some more information, they're going to learn things about your child that they may not have known just from having them in a group environment. So it's important. Be empowered by that and take that. If you take nothing else, do those two things through this process.
Yeah, and I just actually want to add in, because I completely agree with Christy on that. I think it's your chance to individualize your child to the IEP team, who may be sitting there through 3 or 4 of these a day, and it's just child after child after child. One of the best things that I had seen, and actually both Todd and Amanda were great. They always were so prepared for their IEP meetings. They read everything. They knew the questions. But one of the first ones I went to with them, Todd took out a picture of Colin and said, this is who we're talking about. It's not a piece of paper, it's my son. And I think that's so important because it makes everybody at the table stop and really focus on this individual child. So.
And just lastly, you know, we are also parents. We have kids with disabilities. So this part we understand and identify with, so it is important. So this part, this is important. So we put this on a separate slide so you guys would understand the next group of slides that we're going to go through. Because sometimes when we're working with families, they have a concern, say, about placement, which is down here. Oh, that's right. Could I have something? Okay, I don't know how to do it. Placement at the bottom. So, but you can't start talking about placement. You need to start at the top and go through it. So we're going to talk about each of the sections of the IEP and how really the IEP is a flow chart. So if you want to talk about placement, let's say you're not happy with it, and you don't think it's appropriate, how are you going to determine what is appropriate? So we're going to talk about how you get there, okay?
So assessments are, as many of you probably know, what start you through this process. For all of you, sorry, what is it?
It's missing the bottom.
Sorry about that. Anyway, all of you with children between 0 and 3 years of age, you should right now have an individual family service plan. And that plan is tailored for helping your child at that age. When they hit 3, they're going to be moving into an IEP. They need to start assessing prior to 3, because 3 is the cutoff. 3 years and 1 day, and they need to have an IEP. And assessments take 60 days. So you need to make sure that the district gives you a piece of paper listing the assessments that they plan to do on your child, and that you hopefully agree to them or add more in if you feel that there need to be more assessments, and do that at 2 years, 8 months, 2 years, 9 months, so that you have an IEP in place by the time that they turn 3. The assessment should be in all areas of suspected disability. That means not just academic. It means OT, it means PT, APE, music therapy. If your child responds to music, you get a music therapy assessment, because they might be able to get music therapy at school. If your child is not talking or has issues with communication, you get an assistive technology assessment. And then you have somebody come in who knows all of the different systems that they can use and finds out what's best for your child. It's all areas of their suspected disability. So when you do get the document from the school asking you to give approval to assessment, always go through and see what they're testing, and always come back at them if you think there's other areas that your child needs help in. You get reassessed every 3 years. It's called the triennial. And they do assessments in all areas of suspected disability at that point, so that they can make sure that they're addressing all of your child's individual needs. You can ask for assessments earlier than the 3 years. You can't get assessments, the same assessment, within 1 year, but you can do it if it's been over a year. You can say, well, I want another speech assessment. I want to see what he or she is doing and what else we need to do to help with improvement or communication. The exception to that is an IEE. An IEE is an independent education evaluation. And if you disagree with any of the assessment that the school gives to you, it doesn't matter what one it is, I'll just say speech, you can say to the school, I want an independent education evaluation at public expense. And the school either has to do it, or they have to take you to court and prove that their assessment was good enough. And you need to ask that within, there's no set time, but usually within 2 years of the assessment. What the school will usually do is approve the IEE, and they'll give you a list of assessors that they work with. You don't need to use their assessors. You can use your own assessor, as long as they don't charge more than what the school has said that they will pay. And then that person will come to the next IEP meeting and sit down and also help the IEP team determine what they can do to help your child. That obviously can be done within the year, because many times you'll get an assessment and you'll say, this is not good enough, we want an IEE, and then you go get it and you're sitting down again a few months later. So I don't have it on mine either, but let me just, actually, I have more to say, I'm sorry. The other thing with assessments is, look at the assessments when you get them. You can always ask for them before the IEP meeting. Ask for the report. You can actually always ask for the IEP before the meeting. The school does not have to give you the draft IEP. Most schools will. It doesn't hurt, and it actually helps the conversation. But definitely the assessments, you have the right to the reports before the meeting. Get it, read through it, make sure you understand it, mark down anything that they got that was incorrect in it, any questions that you have, and then make sure it's a valid assessment and that you don't want an IEE. You need to make sure that they have your parent concerns in it. Again, by law, it's just so important that the parents are included in everything. So they have to have your concerns, your information in it. You have to look for things like, did they observe your child in school? And if they did, where was it? How long was it? If it's a good assessment, they'll usually say, I observed him from 9 to 9:30 in math, and this happened and that happened, and then on this date I observed this long on the playground, and get a full picture of what's going on with your child at school. You have to make sure it's a variety of methods, different tests, observations, your input. They can't just base it on one thing. And make sure that the assessor was qualified. And if you have any question, find out if they're trained in the tests that they give. Usually that's more in the psychoeducational assessments that you're concerned with it, but just so you know. So.
Did somebody read the box at the bottom?
It didn't print off on mine. I don't think it did. Probably, yeah. It's probably the assessments. It probably is just saying how the assessments are the basis for the present levels, which is the next slide. Okay.
So weird. Okay. Well, I don't have my glasses here, so I can't read mine. It's too small. So basically, the assessments is what's going to lead to the next section, which is the present level. So all the identifiers, that talks all the areas of need from your assessments should then translate onto the present level section of your IEP. So there's that first connector to your flow chart. So there can be formal and informal assessments. So formal, standardized assessments, you get the assessment report. It could also be that the teacher has some informal things that are happening in the classroom that might be included on there. So those are those types. The present level should talk about strengths and needs and how your child's disability affects their performance. The bulleted areas are the areas that are called out separately. They're academic and non-academic areas, but those are the separate present levels that are called out on the IEP. So if your child does not have an area of concern in, I don't know, math, then it would say not an area of concern. But everything else must be addressed. So the reason why this is important is because if your assessment shows an area of concern, it's on your present levels. At the bottom of the present levels, it'll talk about what goals you need to have. That's the direct work they're doing with your child. So present levels are defined. They define areas of need where goals will be developed.
So goals, I think it's probably self-evident why these are important. These are what they're going to work on with your child throughout the year. It is the work that they're going to do. It's the things that they're going to concentrate on, and they will give you progress reports at certain defined times during the year. Definitely at a minimum at the time when the typical students would get their report cards, but it may differ based on other things in the IEP. The goals should address, again, every area that you have a concern in, everything that was pulled up in present levels where your child is falling behind or your child needs help in. You can have an IEP with one goal, you can have an IEP with 25 goals. It doesn't matter. You just want to make sure that the school is addressing everything that needs to be addressed. It's also really important that you look at every single goal, and there'll be a baseline and then a goal. The baseline should be the information about where your child is right now, and that is what will inform you as to what needs to be worked on for the next year. Okay, goals. The Office of Special Education for the Department of Education has given guidance that goals should be written so that the student is up to the academic standard of the year that they're in. That's not necessarily something that matters so much for a lot of our clients, but goals should be aggressive. And OSEP has also said that the goals should be aggressive but realistic. So you want to write a goal that will push the school to work with your child, that will push your child a bit too, so that they make advancement within a year's period of time. The goals need to be specific and state the specific thing that they're addressing. You have to have a way of measuring it so that when you get the progress report 6 months down the line, 3 months down the line, you know whether or not your child is advancing in it. It has to be achievable, as I said, aggressive but achievable. It has to be relevant based upon the needs that we know, and it needs to be time limited. And then they always have an area who's responsible for the goal, and they usually put in the parent. The parent is not responsible for the goal, okay? It is the school district, and it should be the specific providers at the school who are going to work on that goal with your student. It should not have parent in there. It's my pet peeve. I can't stand that.
Yeah. Yes, and you can just ask for if it does say parent, just say I'd like to have it removed. You don't have to have a reason why. It's just not, you don't need to be in there. I want to say something about measurable. We could probably do a whole presentation on goals, but measurable. One thing for you to think about, if you read an IEP goal, sometimes you'll say the child will do this task 80% 4 out of 5 times. We're going to measure 4 out of 5, and they'll be able to do it with 80% success. So we don't really like the 4 out of 5 because you're talking about 64% now. You're not talking about 80% because you're talking about reduced your trials. So there's just some things like that. I wish I would have known when my son was younger looking at this process because their level of mastery then is actually much lower.
And actually, level of mastery, the schools, at least in California, I don't know if this is different anywhere else, they consider level of mastery 80%.
80%.
So you know that. So that's what you should always have. You shouldn't let them get away with lowering that bar.
So the goals, that's where we're at that, they drive services. So from which providers will provide the services and how many hours you'll get. So like if you say, I really want to have OT, that has to be defined before, right? Wait, did I skip one?
No, that's what I have next. Huh. I think services comes next. Try next. Yes, I don't know why I went that way.
Okay. All right, so we're going to talk about accommodations and modifications. This is the how. Accommodations, modifications are the adaptation. They are the access part. So they could be access to curriculum. It could be access to the environment, like physically accessible. So accommodations and modifications are varied, but that's what this section is for. And this is really a fluid conversation at your IEP meeting.
Okay, so services, this is where you're going to have listed out your speech, your OT, your APE, your PT, your music therapy if you have it, et cetera. And it needs to be specific. So you need to know what your child is going to get and how often your child is going to get it. And so it has to have the statement of the services. It has to include the service providers. It has to say the amount of time. Each school does it differently. Some break it down by hours per year, which is mind-boggling, and some do it by month or how many times per week. It will give a statement of the place the services will be provided, and it'll say whether or not it's group or individual. Sometimes they say can be consultation, group, or individual. Nail it down. Make sure that you know what your child's going to get. And then on a personal note, if you, I say personal note because this happened with my daughter. My daughter gets a lot of services. And I realized midway through a year that, she wouldn't go to speech this day because they had an assembly, and then she wouldn't go to OT this day because the OT was out, and they weren't making up the sessions. So during an IEP meeting, I made just a really brief sheet where they check off different things, whether her diaper needs to be changed or was changed during the day, whether or not she went to different services, and if not, when it was going to be made up. So I can keep track of that. I don't know if it's something that you would want to do, but then you'll know that they're getting the services, and if they miss it, there'll be a note as to why they missed it and when it's going to be made up. And I think that's kind of important too.
So services influence placement options, especially when you're considering providers and hours. So placement needs to be the least restrictive environment. We heard that term earlier. There needs to be a continuum of placement. That means that if they have a specialized place for, let's say, 2nd through 4th graders, there needs to be something that steps at the next step for them at the, once they hit 5th grade and above. So that's what continuum is. And then if they are in a type of a special day class, a separate setting, they should have access to their peers. But I want to say one other thing about placement. Sometimes on IEPs, we see that schools say that they've talked about a lot of different kinds of placements at the IEP, and they really haven't. They've made that decision already ahead of time. So on your draft IEP, when you see it, and you're going through it, if it says you've talked about 3 different options, general education, special day class, and maybe a separate setting, then you should be talking about all those things. If you're not talking about it, then they should come off the list.
And just one other thing on placement. if they do talk to you about a couple different options, you have the right to go see those options. You don't have the right to go and see a setting until they offer it to you. But if it's offered, if it's on the table and you're discussing it, you do have the right to go and view it. You'll know in your gut whether or not it's right for your child.
Yeah, take your time. Don't feel rushed.
Yeah.
It's a big decision. So, okay, that's all I had for that one.
So those are the main parts that you're going to see in an IEP document in front of you. And this section now, we're going to address some of the other IEP parts, different things that you might see, you might have questions about.
So this is the individual transition plan. So if you have a student that is in secondary, especially high school and up, this is what that's about. I'm going to go through it briefly, but this is one of those subjects that we could also do an entire presentation on. So an ITP is introduced to your child, and it becomes the driver for the IEP. So it is the front seat. It is the purpose of the IEP once it's part of your child's IEP. It is intended to prepare your child for what happens when they leave the system. So this is for adulthood. So basically you're looking at where you want your child to be when they exit the system, either diploma or they age out. And then you're stepping back and you're backwards planning. That's what a transition plan is. The following areas are considered. It's post-secondary education. This is federally. So post-secondary education or vocational training, employment, and independent living. And there's something called Indicator 13. It's federal. It is the Indicator 13 checklist. So you can use that to look at your child's ITP before you develop it and as you're going through it to make sure it's compliant. I mean, here in San Diego, our largest school district in the county at one point had 0 compliance with their ITPs. So a lot of districts don't do it right. So it's important to be prepared. And my son's 21 now, so there's a lot of things I wish I would have known better and more thoroughly when my child was just getting that ITP and understanding the purpose for it. Transition services must be a coordinated set of activities. So it's not just goals. There are also this other section that an ITP has where it's activities to reach goals. It's like kind of mini goals within. So if they want to do something with employment or independent living, let's just say it's transportation. It might be getting them plugged into transportation. There's a whole set of things. So those activities are separate from the other parts of the IEP. They're based on a student's needs, and they must take into account their preferences. This is also very important that they have buy-in, that they are centered around their interests. And then transition services must start by the time they turn 16. That's here in California. Some states it's 14, so it does vary. So just get to know what that is if you're not from California. And we can answer some questions about this if you have it afterward.
Behavior support plans and behavior goals, these are very important that you get them right, at least the plan especially, because it is the plan that the school will use to interact with your child when your child is having behaviors, and you want to make sure that they're doing it correctly and they're doing it in a positive way, not a negative way. It's part of the IEP, a support plan is part of the IEP if the child has significant behaviors that impede the learning of themselves or of others. And that question is specifically in the IEP, and then the school, the IEP team answers yes or no, and then goes on to write a behavior support plan if needed. If a behavior support plan is needed, look at it, make sure it includes the antecedents to the child's behaviors. You need to know that, and you need somebody who has one-on-one knowledge of that so that you can plan what the right response is. The reason why the child engages in the behaviors, the replacement behaviors the child should engage in, and the interventions the school staff will take when the behavior occurs. So it's really important that you talk to the school about what interventions they're going to take. You need to know what their plan is, and you need to help them determine the best way to handle it if your child has behaviors. In California, it used to be required by law, it's not anymore, that an FBA was done, which is a functional behavior analysis. Basically, they would have the school psychologist go in and shadow your child. and really take very detailed notes on what was going on, what happened right before a behavior, what happened during the behavior, what worked, what didn't. It's no longer required by law. Many times we ask for them because it gives just such great information for writing a behavior plan. And a lot of schools say yes and do it anyway. I think because they know that they want to be able to help stop these behaviors also, so they do it. So if you have just a behavior goal, say, you don't have to have a behavior plan to have a behavior goal. So say that you have a behavior goal and your child's behaviors are escalating and that's not working. It is best practice to ask for an FBA. If the school says no, they say no. But if they say yes, you'll have the best information that you can to start writing the behavior support plan.
And you're opening a dialogue too about it, trying to get more information. So it's usually they're very appreciative at an IEP meeting.
Yeah.
The members are to have that.
True.
Other parts or phrases that you might hear are extended school year, which is not the same as summer school. Extended school year is specifically for students with IEPs that will lose progress on their goals, and so they need to extend their services through the summer program. And sometimes it's other off, like if there's a winter program, it depends on how your school operates. Transportation, also if there's a transportation need, it will need to be addressed on the IEP as well. A health plan. Health plans are, there's a health section on the IEP, so if your student has health needs, those should be explained there. But a health plan is a general education plan, is a general education function. So it's more fluid than an IEP is. So you can write in the IEP that there's a health plan on file in the office or with the nurse, and identify what those health needs are, but a health plan is separate. And then a non-public school is a school that receives private funds. It can be private place, but it also districts place federal funds there. And then a non-public agency is an agency that a district would hire to work specifically with a student that they might need help with behavior or some specific education for the child. Usually it's short term when they hire the NPA, and sometimes they do it to train their own staff to work with the child. One-to-one support is going to look like a specific person from your district that they're going to have work with your child. And then
I want to say one thing on that, just because I was thinking that with the MPA. If you do ask for one-on-one support, be aware that if they assign an aide to you, the qualification level is extraordinarily low. So if you need one-on-one support for a specific thing, such as ABA therapy or something, you need to specify a one-on-one ABA trained aide. You need to specify whatever it is that you need out of that person who's going to work with your child. Sorry.
yes, and a one-on-one should never take the place of the teacher, the highly qualified individual. And then assistive technology usually is a separate section on the IEP. Can be identified with an assessment, but really sometimes the assessment's really about drilling down to the specifics of what type of assistive technology is being used. All those decisions can be made at the table. It doesn't have to be through an assessment. Home stretch.
Sorry, best practice. Just ideas that we have that would help you to advocate for your child.
So first thing is put everything in writing. So that's write an email. If you have a conversation with somebody from school and they promise something's going to happen, follow it up with a quick email saying this is what you said you were going to do and this is the date you said you're going to do it. This is really important to create a paper trail. It also really helps them because then there's some accountability for them to know what you expect also. Recording. This is actually our policy. You'll have to see if you're not from California what that looks like, but it's 24-hour written notice here. Sometimes we tell clients just to write it at the bottom of their meeting notice. If the meeting notice is set up through email, you can just send an email. But just quick thing in writing that you're going to be recording. You can record it on your phone. It's your personal child, your personal use, so you can record it however you'd like. It's nice because a lot of the time, everybody's minding their P's and Q's when it's being recorded. And it also is nice because it gives you something to refer back to, as sometimes both spouses don't get to go. Sometimes somebody needs to hear it. We've had it where attorneys have asked for recordings because we do the recording for our clients. So it's a good practice. I have stacks of even cassette tapes from my son from years.
And one side thing, if you are recording, the school usually also records.
Yes.
And I've heard people say that sometimes there are breaks in an IEP and say the school people walk out and parents start talking and they forget that the school is recording. The school is recording. So don't say anything that you don't want the school to hear if they have a recorder sitting on the table. So just be aware of that.
Yeah. Get organized. I highly recommend this to really put a binder together with the most recent information at the front. And then prepare for your meeting. Request draft documents, the draft reports. Request a draft IEP. Sometimes they'll send you part of it. By law, the IEP should be developed at the table, but there's a lot of information that they can put in it that's just kind of paperwork standard. And it's just nice to kind of familiarize yourself with the flow of things. So they don't have to give you a draft document, but we always let districts know that it's more meaningful for parents, because if you have read everything ahead of time, then when you're there at the meeting, you can ask questions or come prepared with questions. You can have meaningful input. You can also, we offer coaching too, so a lot of our clients will take advantage of it that way. They'll get the documents ahead of time, make an appointment with us, and we do a 1-hour coaching session with them, give them some ideas and thoughts, kind of talk through everything with them. So that's something else you can consider doing. And then we also have, as a side note, an electronic binder, and we would be happy to send it to you guys. So we have 3 different email addresses up here, Christy, Tricia, or info@Pacific Coast Advocates. If you want to email us, we'll send you a pretty great resource binder. And we won't send you anything else, just that.
Okay, at the IEP meeting, odds are you're going to have a lot of people, and they're all going to be staring at you. But the required members are the parent. The child can attend. We usually tell our clients, at least with the younger children, not to have them there. As children get older, have them maybe for part of the meeting, because you don't necessarily want them hearing you discuss their needs and possibly their deficits. So be mindful of what part of the IEP meeting that they're participating in. At least one regular education teacher, at least one special ed teacher or service provider, an administrative designee, or the representative from the LEA. Something
about that?
Oh, yeah.
As the parent or legal guardian, you are a member of the IEP team. So sometimes you'll see on notes, the IEP team thinks this, the IEP team agrees with this. If you don't agree, then it's not the IEP team. They can say, district says this, or staff say this, but just know that as a parent, as a legal guardian, you are as much a member of that team as anybody else at the table.
Absolutely. The other people who can attend are people who can explain evaluations fully. So they might not have the person who did the evaluation, say an OT evaluation, but if they have someone who can explain it fully, then that satisfies it. Person knowledgeable about specific programs, or others who have a specific knowledge of the child. And you can invite anyone you want. So you can invite whoever makes you more comfortable. They are a friend or an advocate.
And this is the last part of this section. At the IEP meeting, you don't need to sign the IEP. A lot of the time districts just want to close it. They have a timeline. They're trying to stay in compliance. But we have clients, too, that come to us after the fact. We signed. We thought it was okay. Later, we realized it wasn't because of these 3 things. So take your time. You are in the driver's seat with this. They can't implement anything, and sometimes they say that we can't implement anything until you sign, and that's true, but that's okay. Take your time. Make sure that that flow chart that we talked to, make sure that the assessments are what you need. Make sure that they identify all the strengths. Make sure the goals are right. Make sure everything is in there the way you think it should be, including your parent concerns. Make sure it's all right. When you're at the meeting, have a printout of the draft. Make notes or bring a notepad. make notes about things that you talked about. If you've agreed that something's going to change, make a note, and then go home and make sure that on that final draft, those things were changed. So really take your time on this. I can't emphasize that enough, that this is important. Don't feel rushed.
And the other thing is, you can agree to parts of the IEP. You don't have to agree to the whole. So if there's something that you don't agree to, you can sign your name and say what you do agree to and that you don't agree to the other.
Yeah, that's right.
So timelines are very, very important when it comes to IEPs. It starts with the assessments and goes from there. It's what restrains the school from just putting you off, and it keeps them to actually having to do their work.
So these timeline basics are for California. If you're not from California, I would look at what your states are. And you guys can read through these on your own. I won't go through them all. But timelines are important because they're really protecting your child's access to their free, appropriate public education. So if they're 30 days late on an IEP, that means 30 days that your child hasn't had the tools that they need to access their education. So timelines are really important. If they haven't assessed in the timeline that's set out, so it's like 60 days for the assessments, if they haven't done it, then again, that's influencing your child's ability to access FAPE. So they're important, and they're mandated. They're mandated, so you have a leg to stand on with these. You can insist.
And then just in terms of the timelines, counting days, by law, day of California again, day means calendar day unless it's otherwise specified. And there are a few places such as records requests where it will specify business days. And you don't count days between school sessions, and it's also stopped for school vacations over 5 days.
But this is also important to think about. So a lot of people think, 30 days. Well, if you're just talking about Monday through Friday, that really extends things. That's a big impact. But it is calendar days for a lot of the things when it's emphasized that or identified that. So pay attention to that. So that's our presentation. We're available for general questions if you have some. If you want to ask us about something specific with your child, we'll be happy to hang around afterward. Just let us know. Does anybody have any questions?
She gets speech therapy now, but it's like a little part of a day, once a week type of a thing. Is there a way to ask for like a daily speech therapy or something like that within the IEP?
Daily, probably you wouldn't get, but you can ask for more therapy. You definitely can. You can call an IEP meeting. Again, in California, I'm not sure of other places. You can have it once you call it, they have to have it within 30 days, and you can. Actually, what I would do in your situation is I would raise it informally with the speech teacher, get the feedback, see whether or not they're willing to do it. Excuse me. If not, you may have to go through the formal channels of calling an IEP meeting. You might have to reassess and find out what she needs. But yes, you definitely can ask to increase it. Yeah.
So looking at the assessment piece again, or if she hasn't made progress on her goals, those are reasons why she would need more time.
Other questions? IEP or anything that you heard them say? Oh, there's two of them. Okay.
Does extended school year carry on into high school as well? Yes, it does.
Okay, and then can you elaborate a little bit on addendums? Because I'm not sure if you specified that or if you brought that up.
Addendum, you mean like an IEP that's more than annually?
Right, like if just that you did want to change something, you can always call an addendum to make changes if you need to, kind of thing.
Yes, you can always call an IEP meeting. Again, by law, they need to convene the team within 30 days. So, yes.
So anything you add at that point to the IEP becomes a legal part of the document. It's just an addition to it. Sometimes some districts do it with notes. They will add things in the notes. It still all counts. Anything that's written down and you sign you agree to is now part of the IEP. So yes, you can call as many meetings as you need throughout the year. You're not stuck with once a year.
And if it's something that the district and you both agree on, you don't even have to call a meeting for it. You can do it through a written addendum also.
You had mentioned earlier about services like musical therapy and other therapies. Who do we actually ask about
You ask
what's
the school
available?
district. Yeah, the case manager. You
So it
ask
would
the
be your
case manager
case
at the school
manager.
district. And like, for instance, with music therapy, there's one place here in San Diego that most school districts seem to use, and they come out and they'll do an assessment and they'll say whether or not they think it would benefit your child. And what they do then is put together a whole CD and a whole booklet of music based on your child's goals that the teacher then uses during the school year. So you do that.
I just because we were talking about that assessment, some districts will say, well, we'll call somebody to come out for a consultation for assistive tech or music therapy. I would say don't do it. Say no, thank you. We would like to instead do an assessment. Yeah, a formal assessment.
You always ask for it in writing. Just make sure you do it in writing because it starts the clock. Okay, and once you ask for an assessment, they have a certain number of days. They have a certain number of days in which they have to do it. So definitely put it in writing.
Okay.
Yeah.
Hi, my question was also about music therapy. We just had our first IEP meeting, but we haven't signed anything because there are some things that we wanted to add to it. And because they're on summer break right now, they're all off, and I'm going to meet with her after they come back. But since my daughter is going to be turning 3 between now and then, is this a problem? Like, in terms of getting the school to do a music therapy assessment, which I didn't actually realize that was an optional service within schools.
Well, you've already had the IEP meeting, and you're moving into an IEP once the school comes back. So really what legally should happen is the minute that she turns 3, the IFSP should stop. So she's just not going to get the services on that until the school starts again with the IEP. But the minute that school opens, just send a written request for a music therapy assessment, and then it'll be the assessment timeline, and they'll come in and say whether or not they think she would benefit, et cetera. So yeah, it shouldn't stop anything.
She's never actually had music therapy, but we've often thought, gosh, that would probably be a good thing. Are there any sort of specific things that one would say in order to justify music therapy, other than she loves music?
She loves music. She responds to music. Personally, when I asked for one for my daughter, who's nonverbal, I just said she seems to respond to music. It keeps her attention longer on whatever task she's doing, and just any positive that you have that you can put in.
And it's educationally related, right? It's about her accessing her education, so anything to do with that. Yeah. Anybody else?
For some of the high school age parents that are addressing transition into adulthood, would you go into the importance of that final IEP meeting as far as the assessments that need to be in place, or the importance of assessments as well as accommodations as those documents are referred to later?
Yes, there's a lot of, I'm not sure I can answer every single, there's a lot of details in there, but in general, that final IEP meeting, actually there doesn't need to be a final IEP meeting, you can ask for it. What is required is a summary of performance, and that is written by your case manager, summarizing where the individual is at the end of when they exit. So that document is really important, especially when you're looking at if your child is a regional center client, or if they're looking at stepping into, let's say, Department of Rehab or any of their next adult services. When they're looking at that document identifies where the individual is at that time. So it is very important. So if there's some type of a connection to like a regional center or developmental services, having them involved in what that looks like would be important, having them there. What? You mean leaving high school?
You mean, how old?
I'm talking about having assessments done before they leave high school, so that, like Social Security, if you're trying to get additional benefits, and if you're trying to get access to HMR services, they're going to pull those school district records and look at those assessments as well as accommodations as well. That's what I was referring to.
So there's mandates for when that is. I'm not sure which state you're talking about, but there will be mandates that summary performance will be in there. A lot of the time, Social Security wants to do their own assessments, but they do look at the last assessments done. So they look at that last IEP. So making sure everything's current. Sometimes I tell parents to request assessment at the end, so they have everything that's current, because a lot of the schools just don't do it. They're only going to do, remember, that base model car. So if you need more, you need to ask for it before. So you're going to have to backwards. If you have a year, then I would request assessment at the beginning so that you have time to not only go through it, but develop all those other documents that need to be done. But Social Security will do their own assessment, but at least they can reference the most current one.
Okay, so what we have the question on is the grouping that on the IEP they put the kids in with. Like for our daughter, they want to lump her in a class where she's more advanced than most of the kids in her class, but she's not at the next level. So she kind of misses out because she's in with behavioral issue children versus academic children. They just kind of put her in the middle because she's not quite in the normal classroom, but she's not in the lower classroom. So how do we get them to do something specific for that when you're just kind of lumped in? What part of the IEP would address that?
Well, the whole thing is she shouldn't be lumped in. It is supposed to be individual, and placement is the hardest thing. And placement is one of the main things that we get clients over all the time, because schools, they have limited resources, so they do lump people together. Realistically, they do it. In that situation, I think you need to be able to prove that she can access her education in the other classroom, because what they're probably saying to you is she can't access it to that level. So find out what supports and services she needs in that classroom so she can access it, and start arguing for those and do it that way, because you're going to have to prove that she can do it. Do you have anything?
I would say we always want our children to grow. So putting them where they're the highest isn't really going to be meaningful for them. So I think having the conversation with your team that you want her to be at the higher level, and what do we need to do to get her there. A lot of what we do with advocacy, we're telling you kind of where the floor is. There's conversations, and most teams, if you come in, these are my parent concerns, this is where I want my daughter to be, this is why, and I want to put supports in place that she can access it there. But then also you can come back and say, if they are still worried about it, you can ask for a trial. That way you can see if she can be successful there.
Just realized we didn't need to have you guys in the dark. We're trying to keep people out of the dark here. Any other questions? Okay.
Can I say one more thing?
Oh, yes,
Can I
please.
say one more thing?
Of course.
I just want to say I know you have our information, and on the last one is our slide. We do coaching. We do coaching even we have out-of-state clients that call in and do coaching. We do a 30-minute free phone consultation, so you can ask questions. I know Tricia didn't bring her business cards, but I do have a stack up here. Yeah. Yeah, it's on the handout. You can call our office. There's several advocates at our office, so we'll call you back and help to answer your questions. Even if you don't move forward with services, we're happy to do the consultation.
Oh,
Okay.
we got one last question. Here we go, you guys. Out-of-state network.
We don't. What I could say is COPA, which is the Council of Parents, Advocates, and Attorneys. Sorry, I had to think of that. Probably would be able to refer you to an advocate in your state. I know we're active in COPA. We've attended their conferences, and any of the speakers there I've seen have been
COPA, COPA.
COPAA.
Okay.
Yeah, and they would be able
COPA.
to help you with that. It's actually not a bad organization for you to join as parents also, because they have a lot of information on their website. And then the one other thing too I would recommend is Rights Law. The website, and they also have books, can help you with any advocacy questions that you have, and they have a lot of good information in it. So it's Rights
The
Law.
name again? Rights?
Rights Law.
Rights Law.
WRIGHTSLAW. Rights Law.